becomes available, correct?
Okay. I'm going to start recording and you can call the meeting to order.
Okay, thank you. I'd like to call the meeting to order. Mr. Zarzaki, can you please call roll?
Yes. Ms. Chick is absent with notice. Mr. Kuzno has not yet arrived. Mr. Dreyer?
Present.
Mr. Quinto?
Here.
Ms. Afonte?
Here.
Mr. Roman?
Here.
And Zarzaki is present. So we have 6 of the 7, or 5 of the 7.
Thank you. I'd like to make a motion to amend the agenda tonight to include a discussion of the public hearing.
Support. Support. Did my support come through?
Yes.
I'm sorry. I'm sorry, I cut out. Is there support for that?
Yes,
Yes.
it will.
Larry, could you restate the motion for the public because you were a little quiet when you were making your motion as well?
Can you hear me now?
Yes.
sir.
Thank you. Bear with me. Sorry, I missed that. So we had support by Mr. Zarzaki?
No.
I Quinto.
Mr. Iaquino, okay. And the reason is there was a last minute item that Paul would like to discuss with the Planning Commission. So all in favor indicate by saying aye.
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 Anyone opposed?
Paul asked to repeat the motion because the public couldn't hear it.
Okay, I'm sorry. The motion was to amend the agenda to include a discussion of the public hearings under new business item 10B. That was the motion, and it was approved. So we can move on to call to the public. Mr. Lippens, I'll let you take over on that and still have the 3-minute time limit, which I can maintain here.
Great. Thank you, Chair. So public, this evening, we're going to have 2 calls to the public. There's an opportunity for anyone to speak. What I would ask for you to do is to raise your hand and I will acknowledge you to make your comments. Please limit your comments to 3 minutes. If you would like to wait to make comments at the end of the meeting, we do a call at the end as well. You're welcome to speak at both times though as well. So that's how we're going to do it. If you would raise your hand, if you would like to make a comment at this time, I will allow you to speak and make your comment in the order that I see the hands raised. And I'm not seeing anyone raise their hands. If you are calling by phone, which I don't see anyone calling by phone, so I believe it's *6 if you're by phone to raise your hand. But I'm not seeing anyone raise their hand. So I think at this time we can safely say no one wants to speak at the first call to the public.
Okay, thank you. So we'll move on to correspondence. All the commissioners received the update of the marijuana application, correct?
Yes.
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 Okay, thank you. There's no public hearings tonight. We'll report to committees. Board of Trustees is Ms. Chick. Obviously, she's not here tonight, so we'll go. And Mr. Kuzno also yet. Yes.
Your audio is out. Audio is out.
Is it Mr. Iaquino? My audio is out.
Whoever just spoke was broken up pretty significantly.
Yes. So Larry, I could hear you, but Sam, when you were making your report, I think you were breaking up.
I wasn't making a report. I was just sharing. I couldn't hear Larry at all.
I understand. Okay.
I was trying to communicate that I could not hear him at all. His audio was out.
Understand. So I believe the chair was asking to initiate the reports. Is that correct, Chair?
Correct. Just a moment. You hear me now?
Yes.
Okay, thank you. We'll go to staff report. Anything from Ms. Bird?
Nothing, thank you.
Thanks. Mr. Lippman, planning consultant report.
Yes. I thought I would just briefly cover what I put in my correspondence. There were a number of people or applicants that submitted updated information with their conditional use application and made a request to have the administration update the scoring. So we have done that actually since the May 15 memorandum that's appeared in your packet. I have gotten a few emails noting that there were items that I did not address in this that I was asked to address. And I haven't had time to reissue this memo. But what I wanted to share with people is that I will continue to update the memo based on best and newest information. But I'm also retaining the original column of where the original applications were scored so that planning commissioners kind of can differentiate that initial application from the revised. I do think it makes sense for planning commission to understand the latest and greatest information. And, as applicants refine their business plan, move through the process of developing site plans, they may have updates and want planning commission to be aware of those updates. So what I'm going to do is try to keep planning commission updated with respect to that. I think since planning commission has added a discussion of the hearings to the agenda tonight, I'll refrain from making comments on that right now, since it's an agenda item. I know, we are making progress and working on related things, including corresponding with the preferred applicant for the North Village site to see how they might progress if they're still interested, given current state of affairs. They are interested, so we continue to kind of work through that. And I guess that's it. That's my update. So thank you.
Thank you. Parks and Recreation report, Mr. Aquino.
Thank you. The community garden is available for residents, preferably, and then non-residents if there are boxes available. They are $10 per box. Please reach out and email to Jennifer Carlisle at Northfield Township or call. She is coordinating the box distribution. It is $10 for the year. And we did a cleanup this last weekend of the community garden and of the walk path that we put in the community park. And it is a 1 mile loop that stretches around through the wooded area that is a very nice, clear pathway for people to walk on. So please come out and enjoy the opportunities that the township has to offer there. And again, the Bark Park is being used. Please, no more than 2 dogs per person there. And please follow the rules. Thank you.
Thank you. Downtown Planning Group report, Ms. Infante.
Yes, so the DDA has not met, although the chair did send out a month ago, just to remind everybody that we're still here, and also that the offer to purchase 75 Barker was still on the table and moving forward. So that was all good news. But really, other than that, I have nothing for you.
Thank you. So item 9, there's no unfinished business tonight, so, oh, excuse me. There is, be 9A, zoning update ordinance discussion, review diagnostic report. With that, we'll go to Mr. Lippens.
Thank you, Chair. So I wanted this evening to put the diagnostic report that includes the items that Planning Commission wanted to address in the general ordinance update. Believe we talked back in February about me including this to go through with Planning Commission. I realize that the project has been delayed, and then with the current pandemic response, we've been dealing with a number of other issues trying to keep business going. But I do think this is important. I wanted to put this on Planning Commission's agenda so that we can re-engage with some of the issues that we want to address in the ordinance. I have gone through the ordinance and made a number of these changes. I'm essentially at the point where there are a few ordinance changes we discussed, particularly to the site plan administration process, that I need to go through and make those edits and then put a draft on your agenda. So the purpose of this discussion is just to reorient Planning Commission into this diagnostic review and discuss questions and get a feel for Planning Commission in terms of setting our work priorities for the next several months, as we also continue to process cases and work with the board to, when they respond to Planning Commission about the emergency marijuana issues, those will be things we'll be addressing as well. So that's my intro. I'm sure Planning Commissioners are familiar with this document, and I'm essentially want to take notes tonight and understand the preference of Commission for kind of re-engaging in these other documents. It would be nice if when we get to the point of adopting, if we get to the point of sending emergency use marijuana standards to the board, that we can also send some of these issues to the board that we've been working on for the last couple of years. So,
Thank you. Mr. Zarzecki, Mr. Kuzno has now joined the meeting.
Yes.
Okay, thank you. So yeah, I had gone over it's quite extensive on all the changes. There's 14 pages. I'm sure we're not going to discuss them all tonight, but I did have a suggestion to the commissioners and Mr. Lippens. And I base it on this, is that some time ago, it's been more than a couple years, I think I spoke with Mr. Lippens regarding the organization of our ordinance. And I see that there are some suggestions that reflect that. But I think more needs to be organized as far as the articles in their order. And before we send Mr. Lippens off on his way to start addressing these, because they do use cross references to ordinance numbers and so forth. So my thought was that perhaps Mr. Lippens, we could have a 3-commissioner group go over all the changes in this document and meet with you at everyone's convenience, so that we could discuss maybe in further detail all of these things, and perhaps start more on a general scope as to the articles in which order we would like them, and then go into the specific.
you cut out, Larry. You cut right when you were saying go into specifics.
Can you hear me now?
Yes, sir.
I can't hear you. am I being heard?
You are being heard.
Thank you. So, but perhaps we can do a 3-commissioner study group and meet and go over a lot of the details and then solidify the recommendation in front of the whole commission. Is that reasonable, Mr. Lippens?
I think so. We've discussed doing a committee before, and I think it would be helpful to be able to do some prep with some of the commissioners for when we come back to the whole group. So I think it's a good idea.
Okay. I guess I could propose that as a motion, perhaps. And of course, I would volunteer to be one of the 3 commissioners, but I will make the motion that the Planning Commission assemble a 3-person study group to go over the changes provided by Mr. Lippens on the zoning ordinance review and revisit in a future meeting with the whole Planning Commission.
I support that.
Supported by Mr. Iaquino. Any discussions, questions on the motion? I'd like to get 2 other commissioners if possible also.
I volunteer.
Mr. Iaquinto and Mr. Dwyer. I see hands go up. So, and I couldn't see Miss Infante. I don't know if she's interested.
I'll be good in support.
Okay, thank you. So, Mr. Iaquinto, did you have a question or comment?
No, sir. I was just sharing that I definitely would like to volunteer.
Okay. So, no other questions, then we can have a roll call vote on that motion. Mr. Zarzeki? Oh, excuse me, Mr. Kuzno?
Yeah, I just, one, oops. Anybody hear me?
Yes.
Yes.
No. Forget it. You can hear me? Okay, I can't hear you guys. So, this is a random thought. It may or may not be the right time for the discussion, but in light of what's going on with a lot of these, this whole virus thing going around and the hell that's wreaked on convalescent homes and senior homes, I was kind of interested in thinking about possibly introducing accessory dwelling units into our zoning ordinance, at least maybe in the agricultural zoning where we have 5-acre minimum zoning. I think that I know that our population is getting older, and I know that I have an elderly father and some in-laws that could be heading that way, and I'd like to have them close somehow to our ordinance. Thank you.
Did everyone? I didn't quite catch the end of the last comments of Mr. Kuzno.
No, you broke up.
I think we got the gist of it, though.
Yeah, I believe he wants to look at it'd be like a secondary residential structure on AR zoned properties. Is that correct, Mr. Kuzno? Mr. Lippens?
Yes. So if I were to summarize the comments, the comment, it was to investigate adding accessory dwelling units in the township with the suggestion that the AR might be a possible district to do it, and offering the supportive reason that we have an aging population and many people want to care for their relatives at home. I think that makes sense. And I think that is, Mr. Kuzno was pointing out that it's supported by the tragedy and difficulty that's we've been experiencing as a nation caring for our elderly in dedicated facilities. and I think that it's a good comment. In many ways, you know, there are things that are good planning and make good sense that have been, you know, come to light and given us an opportunity to think about some changes we can make in the current situation. So I would take Commissioner Cousineau's point as something that's worth discussing with this committee.
Thank you.
I agree also, Mr. Lippens. I agree also. Actually, I had a resident contact me regarding the exact same thing. So I think there's a need for it, and then I think we could definitely look at that. So I agree with Mr. Cousineau's comment. Anyone else?
Thank you. I'm up to, I can hear and talk now at the same time.
I don't know if this is the place to bring this up, but as I was reading through the ordinances, it kept coming to mind the use of tiny houses, and I really didn't see where that fit into our ordinance, and wondered maybe if that has a relationship to something like what Brad is suggesting. But I don't know really what a tiny house is. Is it? It's not a mobile unit. It's not a shed. It's not a house. So I don't know.
Okay. Mr. Lippens?
Yeah, I would say that, you know, the term tiny house could apply to any of those things. But certainly I would say it is aligned with the idea of accessory dwelling units quite well. So I would take that point as well.
Yeah, I see your hand, Mr. Cousineau, but I know you did address the storage container possibilities too. And I don't want to get into a lengthy discussion on either of the topics, but I think that we could also incorporate what Ms. Infante said with that. Mr. Cousineau?
Yeah, I'd like to point out that currently agricultural zoning in Northfield Township does allow duplex houses in the district. And I guess that I'm thinking I'd like to go beyond that, maybe have it be a detached unit that's on the same lot, that obviously is part of the same lot when you go to sell it and for tax purposes. So that's the only difference I'm pointing out there.
Thank you. I agree with that. Okay, anyone else? We have the motion still on the floor. Mr. Zarzecki, can you do a roll call vote on the motion?
Yes. Mr. Cousineau,
Yes.
Mr. Dreyer,
Yes.
Mr. Quinto,
Yes.
Ms. Infante,
Yes.
Mr. Roman,
Yes.
Ms. Zarzecki, yes. 6 passes.
Thank you. So we'll leave it to Mr. Lippens to coordinate a convenient time so that we can meet and take on this review. Sound good, Mr. Lippens?
Yes, it does. Thank you.
Thanks. So we can move on to new business, being A is the zoning administrator's quarterly report. It'd be the first quarter of 2020. Mr. Lippens?
Yes, so we did include in the packet the report from the zoning administrator, which summarizes first quarter activities. This goes through March 31, and things remain to be pretty busy. But as of March 31, the township received 11 zoning compliance applications, 3 for non-residential uses, and 1 was denied for an in-ground pool, but it was approved after additional information was provided. Additionally, there was a shed that was denied and approved also after more information was submitted. The zoning administrator also summarized the marijuana application zoning compliances, which were 16 applications were submitted, and for a total of 31 permits in the township. There were no administrative site plan approvals. There was one ZBA case for 501 East Shore Drive. The applicant obtained approval for a variance from the lot width to depth ratio. That's the quick of it. 2 final site inspections for Living Waters and 811 Main Street, reuse of a commercial building. And then the administrator noted in the office hour report how we're continuing to do services, but we have not been conducting in office hours because the office has been closed. We have been doing a lot of direct communication with different applicants. So,
Thank you. Is there any questions or comments regarding the quarterly report? Mr. Dwyer?
So I was looking at the last paragraph where he's been working with a code enforcement officer and making slow progress on property owners who are non-compliant. How do we go about supporting that?
That's a good question. Code enforcement is an issue that really involves the entire township administration. With Jim Turner as our code enforcement officer, he doesn't work independently. So I actually was having a conversation with our new attorney today when we talked about convening a meeting with the attorney, the code enforcement officer, building official, zoning administrator, Ms. Bird, the zoning planning, building and zoning coordinator, and myself, to run down a list of what the current larger violations are and to discuss our internal strategy. And that's something that we've done periodically throughout the last 5 years is, take a step back to talk kind of what the most practical approach is to addressing violations in the township and, treating each violation or case separately. What we really like to do is help people on the path to compliance. And I know there's been several site plan cases that we've heard at Planning Commission that have been people that want to comply and have filed a site plan to resolve a code violation. That's an instance where we meet with the township administration meets, and we realize the best thing to do is to work with an applicant to resolve the issue through the site plan process, and that comes through to planning. But there are certainly other avenues, which include ticketing, and then if issues aren't resolved, there can be legal action. But there also are administrative. Some things can be addressed through administrative approvals as well. So often it's the zoning administrator taking a lead, et cetera. But the simple question is, we need to meet to develop kind of our strategy and approach for the next 2 years and, or a year, and then continue to go through it. But that'll be pending. So hopefully the Q2 report will have a little bit more information on kind of what we've been able to accomplish, and if we've got a changed approach or an updated approach with new priorities. I'll let you know at that time.
Thank you.
Thank you.
Thank you. I do have a comment.
Sorry, Larry. Larry, Okay.
Okay, can you hear me?
Yes.
Yes.
Thank you. I couldn't hear you. Of course, the township should always want to resolve any issues to the best of their ability without having to go, issuing tickets and having court action. But that's not always the case. And a lot of times, there are situations where that is necessary. And I think it's something that's been lacking in the township, and it really requires the direction of the board and the administration, the township manager, the administration, I want to say, make a commitment to give that person doing the ordinance enforcement the ability, ultimately, if he has to take someone to court and have that authority to do so. And I think it's really been hindered in the past. And I don't know what the new township attorney's opinion is on that. I know what Mr. Byrne, previous township attorney, his opinion was not so much. He didn't really back that idea so much, but perhaps Mr. Fink would have a different opinion. But having done a job like that, it is very difficult, and I do give our ordinance officer credit for what he's accomplished so far, especially not having that ability to issue tickets as much as he may like. But it's a difficult job at best, and it does require a lot of backup from the others in the administration for him to do his job effectively. But I would hope that township board and the manager really come forward with a direction as to what they would ultimately like to see done in the township, so that that person is clearly defined on what he needs to do. So hopefully that can happen. Anyone else have a comment regarding the zoning administrator report? Seeing none, we'll move on to, excuse me. Okay, we can move on to the amended item under new business, which is B, the public hearing discussion. Mr. Lippens?
Yes. So thank you for adding this to the agenda this evening. When we set the agenda, I hadn't anticipated the need to have a discussion on the public hearings that were scheduled tonight, or were scheduled for our next meeting, June 17th. But there have been some developments that I'd like to brief Planning Commission on, and then ask potentially for some action from Planning Commission. So I think overall, we were hoping, and I know there are at least some members of Planning Commission that were hoping that we could meet in person this month, or at least offer a meeting that was partially in person and partially online. Because of notice requirements, we actually had to have more than 3 weeks of notice to send our notice to the papers. So we noticed an in-person meeting with the idea that we could potentially accentuate that with an online meeting options for accessing the meetings at a later date when we had more information. What's happened is Mr. Ains, who has been working to establish our best practices along with our labor attorney, our general township attorney, Mr. Fink, and his colleagues, as well as the director of public safety. How do we conduct safe meetings with an in-person and potentially an online option? Now, Now, with the board meetings, they are capable of making this decision even the week before their meeting, and usually we are as well. With this case, though, because of the 15-day notice requirement, which requires an additional 7 days to get the paper to post it, we had to kind of anticipate where we might be on the 17th very well in advance. And what I would like to discuss tonight is that I have today at 4:09 p.m. Received an opinion from our attorney, which was actually supported by our labor attorney as well. And I'll read that into the record because it's not in your packet, Mr. Chair, if I may.
Yes, you may.
The email from our attorney, James Fink, is read as follows. As discussed with you and Mr. Lippens, because this is a total of 5 public hearings and because they are marijuana CUPs and because of the granting of licenses eliminates licenses for other applicants, I think it is the best choice to cancel these hearings, renotice properly, and hold public hearings at a later date, either by Zoom with notice or after things open up. I understand that the hearings are the only items on the PC agenda, and he said tonight, but it was, I think he meant on the 17th. The commission could reopen the meeting, amend to move the hearings, set new dates, and then close the meeting. Mr. Lippens and I also discussed other items, and I'm prepared to move ahead on those. I'll report separately. Actually, those are not related to the meeting, but it's in the email, so it's worth reading. So essentially, what I was discussing with Mr. Fink was if we had to hold those meetings because they were noticed, I think we have enough time to cancel the 17th. Or if we choose to meet on the 17th, we could cancel the public hearings on the 17th and still meet. But the question that I would ask Planning Commission, I would ask Planning Commission tonight to make a motion to cancel these public hearings because it's been recommended by our labor attorney and our attorney to do so. And the primary reason we're doing so is because the stay-at-home order does not allow us to have people attend more than 10 to a meeting. With 5 cases and our Planning Commission, we're already beyond that. I could say more on it, but I would like to cancel. I would also like to reschedule these as soon as possible. We have been, working to process these cases, and there's important things for Planning Commission to consider. So outside of a motion to cancel these, we may also wish to discuss when to reschedule. If Planning Commission would like to wait until we can reschedule in person for these cases, I can take that direction and discuss that with the manager. If you're comfortable meeting in this format, we could just reschedule and make it a Zoom meeting rather than an in-person meeting. So it's kind of those two things. One, I'm recommending a motion to cancel the public hearings that have been scheduled, and then 2, for discussion, interested in feedback about when and how you would like us to reschedule those.
Understood. Mr. Iaquinto, would you like to comment? I saw your hand up.
Yes, I was going to comment that at this point, I was going to recommend that we just wait until we can meet in person. This is just my opinion, because you're going to have a lot of people from the public that want to participate, and the applicantees, and they're going to have drawings, and it's pretty hard to do all of that over a Zoom meeting. That's just my opinion and thought. And I think it would wind up not giving due process to this, these applicantees if we try and do that over Zoom. That's just my opinion.
Thank you.
Sorry, I'm seeing Mr. Dwyer. And then on a side note, Mr. Iaquino, I probably should have said this at the top, but was this actually something that that you had disclosed that you would like to not participate in conversations on this?
Only regarding my property or those within 1,000 feet. That's what I have stated continuously.
Okay, understand. So we're not making a decision on this. Well, just say I'm raising the issue that we'd seen you kind of disclose that. So it's your judgment on whether or not conflict or not.
None of the items on that were scheduled for public hearing are within 1,000 feet of my property.
Okay, thank you.
Yeah, not only that, I think I don't know if having a Zoom meeting over a personal meeting really poses that kind of concern, but I tend to agree having public hearings in a live format. Although if the majority of the commissioners think that we need to proceed using the Zoom meetings, I don't have an issue with that either. I think it's I think all these applicants have had a lot of time and finances involved in this process, so I don't want to be the reason to put them further off. That's just my opinion. So, Mr. Dwyer, I think, or Mr. Cousineau, did you have a comment?
Yeah, I would agree wholeheartedly with Mr. Iaquinto. You know, this is a public hearing. The public need to be involved. They need to be invited, have the ability to be involved. And not everyone is comfortable with Zoom. Not everyone has access to Zoom. And I don't think we're in any rush here. We can take our time. And I would hate to have a public hearing and immediately thereafter the public feel as though they weren't able to participate. It's more important that the public participate whenever that may be. This is already a contentious issue and we need to give everyone full access, and the only way to do that, I think, is in person whenever that may be.
Thank you. Mr. Cousineau.
Yeah, I get what exactly are the public notices or hearings going to be accomplishing here? Is it just going to be a check the box, we did a public hearing, or is there actually going to be review of site plans and or applications?
So the public hearings are for the conditional use permits. And it's an opportunity for Planning Commission to hear from residents on the siting of the locations. It's also the opportunity for Planning Commission to consider all of the standards as well as the supplemental scoring evaluation to determine if Planning Commission would like to recommend any of these applications be given precedence to the board. So it's important. I would not describe this as a checking the box activity. I think that you may wind up having to take more than one meeting actually to discuss and make a decision. I was going to recommend that at the first public hearing you get a presentation from the applicants and then potentially even table and come back and make the decision at the next meeting. While you consider what you hear from the applicants. It's important. I think that the other thing, so I'm hearing comments from commissioners about whether or not you want to wait to do these in person or not. I think that the other thing I'd be interested in hearing is if we can get support from the attorney to do an in-person and online meeting. if that would be acceptable to Planning Commission as well. So anyway, that's a question I'd throw out there and ask. And I did see Commissioner Zarzecki had his hand up.
Yes, basically, public hearings are for the public, and I agree the public should be able to be present so they can, make their statements during their portion of it. I also like your idea of the fact that with 5 of them, we're not going to be able to get them all done in one meeting. The idea of having a presentation first, tabling it, and then having time to internally discuss it with each of ourselves, not with the other commissioners necessarily, but each of us, reviewing what we've heard and then coming back, and then making another decision at that point. I'm also concerned that we keep only on Zoom, but I think we need to set a timeline that at some point we're going to have a public meeting with the public there. With this 3-week notice, perhaps we should keep setting them at each meeting and canceling them if we have to, if that's the attorney's opinion, so that we can have them as soon as possible. As Mr. Roman stated, these people have put a lot of effort into their applications. They put a lot of time and money into them. I don't want to keep dragging it down the road if we don't have to. If we're going to do a 2-part meeting, maybe the first part is a Zoom meeting with them if the attorneys agree with it. And then we have a public meeting afterwards where everybody's present. So I pretty much agree with everybody at this point on our options.
Can I pipe in here? I think I agree with everyone. I think the stakes are so high for the people who are applying and for the public, and also because some of the criteria, everybody's getting zeros in one section about the 1,000 feet from the library, daycare, or park. That's something to consider. I mean, we need to hear what people think about that. And as someone whose internet absolutely sucks, I really think it's important that people be there in person to be fully heard and to see they are being heard.
Thank you. Mr. Dwyer?
I think Mr. Lippin's suggestion of a combination in-person plus virtual access is an improvement, whereby those people who don't feel comfortable coming can still participate. In the mail today, I got an invitation to apply for an absentee ballot, so that if you don't want to go vote in person, you don't have to. I think this is the same sort of thing. If we, can combine the virtual participation with the in-person participation, you can take your choice. That allows more people to participate, gives them more options, and excludes less people. So I think that's a good improvement. If we could make that happen, that would be, my preference.
Thank you. I also agree with Mr. Dwyer. I think it should include both, Mr. Lippens. There may be people that don't feel comfortable going to a public meeting, whatever reason it may be. And I think the option of the Zoom, if we could include, it's more inclusive. So if it's more inclusive, I'm for that. I have, although I didn't expect a full blown out discussion on the process tonight, I'm going to, and everyone else has given their opinion, I'm going to give mine. As I've said before to Mr. Lippens, that I have an issue with the Planning Commission being the one given precedence on the applicants. The Planning Commission was not the entity that reviewed the applications, nor did we do the scoring. That was done from other individuals. And I think I have a very simple matter for the Planning Commission and Mr. Lippens to process these, is that you did, the review's already been done already been done on the site plan and the conditional use permit. the next step would be to put the ones that are decided upon in front of the commission, and we strictly look at whether the conditions are met for the conditional use permit and whether the conditions are met for site plan approval. That should be the extent of the planning commission's involvement on the review. At that point, if the applicant had passed both of those things, then we would forward those to the Board of Trustees, and they should be the ones that decide precedence of the applicants. Simply because of the fact the board is the one that designed how the application process goes. So the planning commission remains just a commission to review the necessities that the ordinance presents to the applicants. If they meet those requirements, then I think we should pass it to the Board of Trustees and let them set up a meeting to decide the precedents. And I'd like to hear from Mr. Lippens and the rest of the commissioners on what I've just said.
I agree. Second.
I agree as well, 100%.
Mr.
So I would just say that, planning commission doesn't need to make a motion to agree with the chair or not. Certainly, I want more discussion on the matter, and I'd like to hear from everybody. But the way it was set up is that you have the ability, based on the review, to advance or give precedence to one of these applicants, or several of them. And I would say you would do that via motion. I make a motion to give precedence to this one to the board. The board would have to concur or not. But you don't have to give precedence to any of them. You could say, we find that this meets the conditions and we recommend the board approve or consider supplemental scoring or not, right? So your suggestion, Chair, is a good one. If the other commissioners agree, you could review these as you would any conditional use. I still think it's very valuable for you to hear from the applicants, to hear presentations about how they feel they can differentiate their businesses in the township. You can certainly, forward whatever recommendation you'd like to the board for their consideration. So,
Mr. Lippens, before you go to Mr. Dwyer, I know he has a comment. That in doing what I suggest, we are expediting the process. Why would the applicant need to do a whole presentation to the planning commission when we are not the ones that are deciding precedence on the applications? I think it is much better reserved for a presentation at the board when the board decides to have on their meeting agendas the time to decide the precedence. So in other words, we're putting these applicants through additional requirements at the planning commission level. And as I just suggested earlier, I don't think it's our position to decide precedence. I think our job is to decide, yes, the conditions are met, and we forward it to the board and let the applicants make presentations then. I think we're making it much more complex than it needs to be. And I think we're also putting a drag on the entire process in doing so.
Certainly, just to respond, I think the term presentation could be taken a number of ways. In every conditional use, generally we hear from the applicant during the public hearing. So I don't think we have to go much beyond that, but I certainly think if the applicant wants to speak to their application to planning commission, we should allow it. And that's all I mean.
And I completely agree. As always, the applicant has a right to make a presentation to the planning commission. But the fact is that in this case, a presentation deciding their precedents with the township is much different than a presentation just presenting the planning commission their potential business for approval or not. It's a huge difference.
Yeah, I think we agree on the purpose of that. I agree with you.
Right. Thank you. Mr. Dwyer, I'm sorry.
Dwyer, right?
Well, if I look at the applicant's that currently have precedence, if you will, or currently have motivation to continue based upon their submittal and their scoring. They're all sort of clustered very close to each other downtown. And whilst downtown's a great place for them, I didn't envisage like an intersection with a gas station on every corner. So what happens? Is it first past the post excludes everyone else? Or are we trying to make decisions that 3 within so many blocks is not the right mix for our downtown? And that's where I think we're sort of unwittingly heading by having these applicants present to the Planning Commission site plans that we are reviewing. But in reality, the question is, are that number of businesses similar, right for that location? And I think that's beyond our remit. And I would agree with the chair that, this is more a question for the board as a whole before we start deciding that. And we pick winners and losers.
Thank you. I see Mr. Cousineau.
Here. Yeah, so I agree with Mr. Dwyer and with Mr. Roman, your assessment of streamlining. It makes sense to me. I guess maybe maybe I'm slower than everybody else in the room. What are we talking about here in terms of numbers? Are we talking about eradication of certain types of businesses? And how many have gotten to the point of review at this point? I know we got the chart there, but point of review, and under each category, how many would be licensed, possibly based on what we received so far, and how many would be eliminated? Oh.
So Commissioner Cousineau has frozen. He may come back.
Did you hear that?
You're coming back, but still breaking up a little bit.
All right.
I hear you.
My question was regarding what are we doing in this process? What would we be doing? How many people?
Did we lose him?
Commissioner Zarzecki, did you have a comment while we wait for Mr. Cousineau to come back?
Yes, I can agree with the statements that we're not supposed to be setting the precedents of who's going to get what. Basically, we just approve whether or not they are in compliance with our, zoning and everything else. And the board is the one that is going to be responsible for taking care of who's going to get which one. And obviously, there is a limited number of them. And there's more applicants than what we were going to allow. So, but for us to determine who's going to be downtown and how close to each other, if that's acceptable, that's the board, not us.
Can I make a comment? It's Cecilia. I really agree with what everyone else has said, mainly because as I was reading through the criteria, I was wondering about them. I mean, I don't know what a community commitment program is. I don't understand what some of these criteria are. So to make any sort of a decision or to even listen to and understand the feedback from the public, what is the point? I really do think in terms of supporting the applicants and streamlining the process, and also following suit with who really is the authority in the decision process, it completely makes sense for the board to be holding this meeting and not for us, and also not for us to keep kicking it out because of something, is not our fault with this COVID-19. We want to support everyone, but we just can't have this in-person meeting. And I think it's not worth trying to have one while things shake out. My opinion.
Thank you, Ms. Infante.
As
Mr.
a point
Laquinto?
Can I clarify something?
Certainly.
Planning Commission will have to still hold the public hearings on the conditional use, just to make sure everyone understands that. And then in terms of all of the information and the scoring materials, as part of that, you will receive the complete packet that's submitted with the conditional use evaluation, which contains information about all of those things. So even if you don't want to make a decision to recommend any particular application be given precedence for citing, you'll still need to read and fully understand the business that's being proposed. And you don't have that information yet, but it will be a part of your packet when prior to the meeting, just so you know. So it's understandable to me that you don't understand everything because you haven't read everything. And I read through several bank boxes full of materials. There's a lot of information to digest. So I thought it was an important clarification to make.
Mr. Lippens? Mr. Lippens? Everyone can hear me?
I can hear you, yes.
Thank you. I would like to, and since we're on this discussion, we all received the scoring process in our packet. It was in our packet for tonight. Obviously, there's already been a precedent set because there are, if you look at the scoring, there is a comparison to one facility to another that was already scored. So it's really not a secret. It's already out there on the scoring system as to which are the 3 licenses that are available. Am I correct, Mr. Lippens?
Well, an evaluation has been conducted by the township administration, but no precedent has been set.
Okay.
The effort that we've made is to be transparent in our processing of the applications, not only to the board, but also to the public. So we want them to know not just what we think, how we scored their application, but also how all the applications scored. And then additionally, as I mentioned prior, you've got now 2 columns where we've adjusted the score based on the information. And partly that is to allow the applicants an opportunity to express what they intended in their application. Because what we want to do is fully understand what's being proposed and communicate what's being proposed to both Planning Commission and the board. So that's the purpose of that revision. So yes, we want to share kind of this is how the applications were scored, but we also want that application to have meaning in the sense that it is a communication of really what's being proposed. And we need to communicate with the applicants as well to understand what they're proposing. So what you have is an analysis, scoring analysis that's representative of the administration's best effort to understand what's being proposed by the applicants and to accurately represent those proposals to the decision makers in the process. And but the precedent is something that really can only be set by the Planning Commission and the board. And that's because the board made the decision to make that a part of the conditional use process, which is consistent with the State Zoning Enabling Act and what other communities are doing. So just to summarize, we don't have to give precedence to any of the applications. We can process them as they come in, and Planning Commission can do exactly as the chair suggested, which is to consider each applicant individually and allow the board to decide if they want to make a decision on precedence independently. And I do agree with the comments that the chair made about how it simplifies the process a little bit, because it makes it so that the board doesn't have to both consider Planning Commission's recommendation as well as the applicant's requests and then their own recommendation, right? So it certainly is easier for just to establish one precedent or not and leave that to the board.
Correct. I agree with that. Now, Mr. Lippens, I'm going to delve into it a little further. Based on the scoring update that you gave us tonight, there are 3 licenses available for retail, correct, in the township, in the township.
There are 3 for provisioning and 3 for adult use, but everyone will wind up getting both because the provisioning is what they need to get first in order to get the retail.
Okay, so it's obvious to me that the decision has already been made on the 3. Am I correct? According to the scoring.
No, I mean, I would disagree with that. I think that the administration has made an analysis, but I know for a fact, as I mentioned, there are several people that have pointed out that I didn't accomplish everything that they asked me to accomplish at the beginning with respect to updating their scores. So I need to relook at a couple issues that, and I may issue another score, right? But the actual decision on precedence has to be made by either Planning Commission or the board. It's not made by the score. And the evaluation, even planning commissioners or the board might ask for more information or have questions about the evaluation, which could result in us rescoring it. So there's kind of 2 approaches to this, Chair. One would be for us to say, let's have everybody individually score it, and then we'll average them all out and say this is the best, right? And that type of a system really doesn't result in much clarity. So what we're doing is a different approach, which is your administration is charged with developing the scores, answering your questions, but also answering the questions of applicants. You have to remember that these scores are not the setting of a precedent. What they are is a decision-making tool or an analysis. I wouldn't even expect that a decision to give one applicant precedence would necessarily need to be based solely on the scores. It would have to be justified, and the reasons for setting a precedent, I would recommend, be expressed in the motion to give a certain application precedence. This is to point out that no, I do not believe any precedent has been set for any application. What we have done is scored it based on best available information. And if new information comes, we want to track that as well. But overall, the purpose of us working with applicants is to understand their desires, their businesses, and to help facilitate the decision-making process. And that's what we'll continue to do, for sure.
Okay, let me put it a different way, Mr. Lippens. So are you suggesting that the Planning Commission is going to look at both conditional use permits and site plans for all of the applicants?
As many that apply, and anyone that applies is entitled to have their application processed.
That's my point. Obviously, there may be some that will not be approved or fall short of even providing the information necessary to go in front of the Planning Commission. Am I correct?
I really wanted to do the pudding tonight.
Yes, it's possible that will happen. It's possible that, and as of the memorandum that I put in your packet, we had only received 5 applications. I think we have since then received another application. I have to double check the status. And we're working with other people, but you never know. People might not respond or abandon their product, and we can't hold up everyone else. So
That's
file an application, we're going to process it.
my point being is that if someone doesn't have all the necessary information to come to the planning commission, why would they come before us? That needs to be done administratively is what I'm saying. It should have already been done for us to have put out a public notice to have a public hearing on such and such of application. Am I correct?
I'm not understanding your question now, Chair.
Okay, we have put out a public notice for a public hearing on X amount of conditional use permits and site plan approvals. Am I correct?
Correct, yeah.
So we know there's X amount of applicants that meet our requirements.
Correct.
Those are going to be the first ones to be looked at.
Correct.
So if everything passes, if everything is approved as far as meets the requirements as a conditional use permit and a site plan by the planning commission, they will be forwarded to the board of trustees for them to make a decision on precedence. So
Correct.
In the meantime, so we only have 3 licenses for the township as far as the retail and, as you said, the what were the 2 categories?
3 sites. 3 sites. The 2 categories are provisioning center and retail.
Provisioning center and retail. So chances are there's already the 3 that have all their ducks in a row are slated to come to the planning commission. Those will be forwarded to the board of trustees. So why would the rest of them want to come before the planning commission, go through the whole process if they don't have their information?
And there may, so I understand that question. There may be people that have decided not to apply or move forward because of the competition in the process, which was the whole point of letting people know the evaluation of their initial score was to decide if, based on that initial application, they wanted to proceed with the cost investment to go through the site plan and conditional use process. So
Right.
It is possible that we will not receive any more applications.
Correct. Because
Okay, yeah.
because we have 3 available or 6 technically, and we have 3 3 businesses, potential businesses that already probably meet the requirements. Am I right?
I mean, yeah, probably, yeah. I mean, I think that every application we received were from business owners that have a real interest in citing a business and the capability to do so.
Right. So I guess my point is that in looking at the scoring update, we know that we probably have 3 potential applicants that meet all the requirements and probably should be forwarded to the board of trustees and let them make a decision on which one takes precedence. That's what I'm saying. So why are we going through all of the other song and dance is what I'm asking.
I don't know. So I think the only answer to that question is that people have the right to file an application to develop a business on their property. Anyone that filed in this first group has been already given a level of precedence in a sense because we've said we'll process their applications before we accept new applications. You know, I think that in lieu of someone formally withdrawing their application, we will continue to process applications as they're filed.
As we should. I do not disagree.
Mm-hmm.
And what my point is that we probably have sufficient applicants for the amount of licenses we have available. Of course, the township and yourself are going to process further applications. And of course, they would be put in some type of precedence behind the ones that already have everything in order. And I'm not saying that any applicant should be denied any part of the process. That's not my point. my point is, why are we going through so much to answer a question that we already know the answer to, which is we have applicants that are going to meet the requirements. Why delay it any further? I guess that's my point.
Yeah, I don't think we should delay anything at all. I think we should hold public hearings with a sense of urgency, which is what we've been trying to do. Obviously, we have some pretty major difficulties going on right now, disrupting our public process. But even I would say our applicants have been working diligently to stay on top of their application. And, you know, we need to and continue to work towards scheduling public hearings when we can do so safely in accordance with our attorney's advice on that.
All right. Thank you, Mr. Lippens. I won't belabor the point any further, but I see Mr. Kuzno has his hand up.
Thank you.
Mr.
Okay,
Kuzno.
can you hear me this time?
I can.
Okay.
Now you're breaking up.
Question is, yeah, and how about now? It's better now?
Yes, sir.
Okay. Coded chart that you gave us, Paul. I see 3 green lights here, all looking for retail, and I see none of those names on the public hearing that's available public hearings. How is that? How does that play out? Hear me or not?
I didn't catch enough of it to understand how to answer.
I'm just curious. I mean, so how do we get public hearings for ones that don't qualify already, and we got no public hearings for ones that do qualify?
So I'm not sure. So what I heard you say is, how come we have public hearings scheduled for those that don't qualify and no public hearings scheduled for those that do qualify?
Yes.
Is that the question? So
yeah.
The answer to that question is that if you file an application for a conditional use, you are scheduled for a public hearing. So I guess my answer is everyone qualifies. The public hearings that were scheduled are people that qualify to have their application heard at a public hearing. Everyone who files a conditional use permit application has the right to have that public hearing scheduled. And at this point, you know, even if we were to recommend denial, we would still schedule the public hearing, and Planning Commission would have to concur with our recommendation and then forward that recommendation to the board. So
do we not know about the status of the 3 that we say are approved so far? Why they haven't applied for application and public hearing?
I don't know. I don't have a report this evening on the status of any applications that weren't included in my memorandum. So if someone hasn't filed an application, they may intend to. They may have told us they intend to, but I'm not prepared to discuss the applications of all of them right now. And I can certainly prepare an update for you on the status of all of them. I did at a prior memorandum, but things have changed since even that first application. And the last memorandum I put on your communication tonight was about those that had filed an application and were ready for a public hearing on their application.
Okay, thank you.
So, I mean, the simple answer, Commissioner Cousineau, is that those other applicants hadn't filed an application to schedule a public hearing at that time.
All right, good.
Yeah.
Yep, thank you.
I saw Mr. Dwyer.
If I can sort of summarize the sense of what I'm hearing here is that notwithstanding everyone's right to a public hearing and their application
No, you've already had all
being
the
considered,
checkers.
we could have 15 public hearings and 15 applications for 3 licenses. We send all 15 to the board in some form or another and they pick 3 winners. And I think the sense is, why don't they pick their 3 winners, send them to us and see if they can get through the planning commission? Is that what everyone's trying to get at here?
Well, sir, the planning commission makes the decision on the site plan. So I think you could table a site plan decision until you hear from the board on whether or not they approve the conditional use. However, typically we approve site plans conditional on them receiving that, just so that we process those applications parallel and don't unnecessarily delay people for a month.
But this is not typical. This is not one person coming out of the woods saying, I want to do this. This is a flock of people in a horse race.
Agree. So, you know, theoretically, you could discuss that and say, you know, we're going to make our final decision on site plan after we hear from the board on these conditional uses. It's not a typical situation. It's not a typical time period to be doing this. So we're, you know, kind of doing our best at processing this as quickly as possible. But your point is well taken. I think we had a comment from Commissioner Zarzecki again.
See what your father's up to.
Basically, we should just do our job, process the, public hearings, pass them on to the board. That's what we've been doing all along. We haven't taken any sides as who's the better one, who should get it, who shouldn't get it. And although it'd be nice for the board to first pick them for us, I don't think we're going to have that option. I think the board's just going to want to see us do our job the way we're supposed to and pass them on to them, and they can do what they are supposed to do at that point.
Normally, I would completely agree with you, except that I do feel that the conditions we're operating under put those applicants at such a delayed and literal expense that if there's a way we can still do our job and do process, but streamline the situation so that the deciding authority is the one that makes the decision, so that when we need to make our decisions, it comes to us with those criteria. I just feel that we're in a situation that requires a little more creative thinking, and maybe we're not allowed to do that. So, I mean, certainly want to have integrity, but I just feel like we're trying to do the best for everyone, and kicking the can down the road is not the best, but it's not our fault either. We're really in a situation where we're a little, our hands are a little tied.
I agree. We would be in a situation whether we were having the COVID-19 issues or not. My viewpoint is the board should have set a deadline that all applications required had to be in by a certain time period. And those that were in by that time period, we would review. The ones that, like you said, wanted to drop out, not continue, they would do that. But we don't have a time period. We just keep kicking this can down the road right now.
I don't think that that's entirely true, Commissioner Zarzecki. Just so we did establish a time period for people to file their applications, and then we reviewed the applications, and issued a response on whether they were complete, and then the next phase was for the filing of site plan applications, which we've been doing. And once the site plan applications are filed, we review them and then we schedule public hearings. So, the process that I'm hearing you want to follow is exactly what we're doing. And, with respect to Commissioner Infante's comment, I just, it's important to understand that the public hearing is statutorily required to be held at the Planning Commission. The board does not have to hold a public hearing, but they can reference the results of your public hearing. So your role in the process is to hold a public hearing, allow the applicant to speak at the public hearing, accept the staff's recommendation, and then you make a recommendation to the board. And your recommendation is kind of the same thing you would recommend on any conditional use. We recommend you approve this conditional use. Well, they've met the standards. We heard from the public. We didn't, or we did hear any concerns from the public. And then the board makes a decision. I think the only question is whether or not you want to assign a precedence to that. And whoever makes the motion would determine that. And I've heard discussion tonight that I haven't heard any planning commissioners say that they felt inclined to give a precedence at this point in the process, noting that that decision, the ultimate decision on the conditional use, is the board's decision anyway. So, but, we have to follow the process, and that's what we've been doing, following the process. These things take time. I mean, it takes a lot of time to get through one conditional use application with one applicant. I mean, it often takes 6 months. We want to go as fast as we can, but we're, dealing with a lot of cases and a lot of information, and we've been going through it as quickly as we can given the circumstances.
I see Mr. Iaquino.
Thank you. I was going to recommend we just move on. We've discussed this and we've discussed it and we've discussed it. I'd like to move on with the meeting. That's just my viewpoint. Thank you.
Okay, I think if everyone agrees, we need a motion regarding the public hearings that are scheduled for the next July 17th meeting. I'll make a motion that the public hearings be rescheduled at a later date that can be held an open public meeting, and necessary public notice be given for those hearings at a future date.
Second.
Supported by Mr. Zarzaki. Did I cover that, Mr. Lippens, for you good enough?
It's clear to me.
Okay. Any questions on the motion? And I just want to make note, the reason is that it was advised by the administration and the township attorney and the labor attorney that that was the direction that they wished us to take. So obviously it is an administrative decision because obviously the township offices are not open yet, and we can only guess as to the conditions and when they will be open for us to have a public open meeting. So, Mr. Zarzaki, any other questions or comments? Mr. Zarzaki, can you do a roll call vote, please?
Yes. Mr. Kuzno.
Yes.
Mr. Dryer.
Yes.
Mr. Quinto.
Yes.
Ms. Afonte.
Yes.
Mr. Roman.
Yes.
Zarzaki, yes. 6 present, approved.
Thank you. Okay, moving on. Item 11, approval of proceeding minutes from May 6th, a regular meeting. I make a motion we approve the minutes and dispense with reading.
Support.
Second.
Supported by Mr. Iaquino. Any questions, comments, or corrections on those minutes? Seeing none, all in favor indicate by saying aye.
Aye.
Opposed? Ayes have it. I'll go to final call to public. Mr. Lippens.
Paul, you're muted.
Paul, you're muted.
Thank you, Sam. I do see that there is one person in the public that has their hand up and would like to speak. If anyone else would like to speak during the public comment period, we would ask that you keep your comments to 3 minutes. I'm seeing another person has raised their hand. If you're participating by phone, I will allow you to talk, but to raise your hand, I believe you press *6 to raise your hand. In the meantime, I see two. I will take you in the order that you do. The first person wishing to speak's name is Travis Copenhaver. Travis, thank you for coming tonight, and I'm going to click to allow you to talk.
And he has 3 minutes.
Travis, you have 3 minutes.
Hi, can you hear me?
We can hear you.
Great. Hopefully, I won't take the full 3 minutes. Thank you so much for holding these meetings. This is the second meeting I believe I've had the pleasure of attending, and you guys have vastly improved your craft on these Zoom meetings since last time. So, I'm an attorney. I do licensing work, and full disclosure, I do represent one of the applicants moving forward with the Provision Center retail location. That would be the Treehouse applicant. I also have done cannabis work with several interested parties in your community with other license types, which is why I was speaking last time. I like to thank all of you for tackling this issue. I've done at this point over 100, probably more than that, both competitive and non-competitive municipal applications for both medical and adult use applications. It's always a very complicated and challenging process as I see it for municipalities, and I thank all of you for tackling that, and very encouraged by the seriousness you're all taking it. I just want to kind of more for the record state that I know that my applicant, my client, wants a fair process across the board. We understand that there are various steps along the way until we get to our final selected winners. But what I don't want to get lost here, as you guys are kind of looking at what this commission's role is on the process, is the types of timelines and costs associated with those timelines that these applicants have to face. There was a set of basically procedures that all the applicants in your community needed to follow to even submit applications. And there were timelines and suggestions for that. In addition to the ordinance, there was a set of application procedures dated December 4th, 2019, with an application deadline to submit information by January 24th, 2020. Obviously, in January, the world was a very different place. COVID creates challenges for all of us on the applicant side and the municipality side. I think, like, when you are considering the role in the process and what applicants are going to do, everyone wants to continually improve. But we also need to, especially in light of the mentioning of rescoring, keep in mind that I can speak on behalf of several applicants in your community and outside of your community. The more time an applicant has to prepare information, the better application they're going to submit. So getting an application in by the end of January is a very different scenario for the types of people I work with than getting an application in with additional information in May.
30 seconds, Travis.
Thank you. I'll wrap it up. The only other thing I want to say is, and it's been mentioned several times and we truly appreciate it, COVID is an unprecedented situation for self-funded small business owners. And the types of scoring that I think are going to be relevant in the world today might be seen through a different context than when these applications were put together. The group I represent is primarily self-funded, and this is a very difficult time when we see delays. We understand delays, but please just keep that in mind, and thank you so much.
Thank you.
Thank you, Travis. All right, and you got in there under the ringer too. I also see Jason Negri would like to speak. Jason, I'm going to unmute you, and you have 3 minutes.
Can you hear me?
We can hear you. Thank you.
Excellent. Sir. Thank you. I noticed quite a bit of internet lulls and difficulty with communications tonight, and I had my own, unfortunately, towards the very beginning of this meeting, and I missed the very substance that I had hoped to hear. So while I appreciate that you don't necessarily respond to public comments, if and when you feel so inclined, if you could just let me know quickly whether any substantive discussion took place on agenda items 5, 6, and 7, specifically regarding the rescoring. I heard all of the discussion later on regarding the addition that you made to the agenda and the whether or not it was appropriate for the Planning Commission to be hearing these, whatever else. But I did not hear, because my internet was out for about 10 or 15 minutes, I missed whether or not there was any substantive discussion regarding the rescoring of the applications themselves. And if there was, if you could just give me a bottom line, I would greatly appreciate it. Thank you.
Thank you.
Thank you, Jason. I'm going to mute you now. At this time, I'm not seeing anyone else in the audience with a hand raised. I do see one person participating by phone. Again, if you'd like to speak, I believe it's *6. But seeing none, Chair, I would return to you.
Thank you. We'll go comments from the commissioners. I'll start just in response to Mr. Negri's comment or question. There may have been substantive information or discussion regarding the rescoring. You can always go to the township website and watch the entire meeting. It'll be posted there. So if there's anything you missed, you can catch up on it there. Am I correct, Mr. Lippens?
So I would say that item 6, the rescoring correspondence, we did not have discussion on that item. That was a communication.
Okay, if
Am I remembering correctly? That's
okay. If that's what he's referring to, is this the course?
It is. I may have addressed that in my report of the committee under 8. And if Mr. Negri would like to go back and read or watch that portion, I would advise him to look under 8 when the planning consultant report happened. I may have explained that report, but I don't believe there was any discussion at that time as well.
I agree. So other than that, we'll move on. Mr. Zarzaki, comments?
I have no additional comments right now.
Thank you. Mr. Kuzno?
Thank you.
Mr. Aquino?
Yes, I have one, sir. The minutes of the February 19th meeting show that I was absent. When we approved those, I addressed this at that time that I did show up at 7:12, but it was not changed in the minutes that are on the township site. So if that could be done, I'd greatly appreciate it because I was not absent. I did show up. I was late, but I was there at 7:12 for that meeting.
Thank you. Perhaps Ms. Bird can help with getting that corrected.
And that's it. Thank you.
Thank you. Mr. Dwyer?
Nothing further. Thank you.
Ms. Infante?
Thank you. No more comments.
Okay, with that, I'll announce the next regular meeting being June 17th, and I make a motion to adjourn.
Support.
Support by Mr. Aquino. All in favor indicate by saying aye.
Aye.
Opposed? Ayes have it. Thank you very much.
Thank you.
Thank you.
Thank you, everybody, and thank you to the public that came to participate.
Yeah.
Good night.
Thank you.
Good night, everyone.
All right.